Assalamualaikum and a very good day I bid to our respected lecturer, Madam Najah Inani, and the rest of you who are watching this video. I am Nik Nur Alia, and together with my group mates, Aina Husna, Aisha Imanina, and Tayalani, we will be presenting on the topic of the effects of marriage on status and property for Muslims. According to the common law principles, the wife will merge with her husband as one legal entity. This rules out all of the wife's legal rights, namely property, earnings, contracts, and others. All legal actions require permission of the husband. Undoubtedly, the common law principles are rather not suitable to be applied in today's day and age. In Malaysia, we have, for the effect of marriage on status and property for Muslims, our Married Women Act 1957 and Islamic Family Law Act 1984. We also have cases applicable which also take as precedents, and all of these will be discussed by my other group mates, namely Aina Husna, Tayalani, and Nina.
Assalamualaikum and good day, Madam Najah. My name is Aina Husna Azhan Hawari with the matrix number 288557, and today I'll be explaining the relevant law governing married women, mainly focusing on the Married Women Act 1957. There are two legislations, namely the Islamic Family Law Federal Terrorist Act 1984, or known as IFLA, and the Married Women Act 1957, which govern women's personal status and her capacity to acquire, possess, and dispose of property after marriage in Malaysia. The Married Women Act 1957 took effect on 15 August 1957 and was significantly amended in 1994. So I'll be explaining the relevant sections under the Married Women Act 1957. First of all, in Section 3, it is clearly stated that the Act applies to all married women and their property, rights, and obligations as long as they are subject to Islamic law and the customs of Malay people. Moving on, Section 4 provided the ability for married women to acquire, own, and dispose of property, be liable in torts, contracts, debts, or obligations, sue in their own name, and also reside in her to be sued. In other words, a married woman now has the capacity to acquire, own, and dispose of any property. The property rights of married women are addressed under Section 5 of the Act. According to this section, if the property was that of a married woman, or if it was property held for her separate use in equity, then that property belongs to the married woman in every respect as if she were a femme sole or an unmarried woman, and it can be disposed of in accordance with that status. It is no longer possible for the husband to be held liable for his wife's torts, prenuptial contracts, debt, or duties before or after marriage as a result of the statute. In the meantime, Section 9 describes the rights of married women with regard to the preservation of their property. Aside from that, Section 9, subsection 2 provides both the husband and the wife with equal standing as well as the ability to sue each other in civil court for torts committed against them in order to protect the security of their property. This right is extended to both parties in order to ensure that they are able to protect their assets. So, moving on, the following part will discuss the obligations and responsibilities incurred by the wife prior to their marriage. In Section 10, it is stated that a woman, even after she has married, shall continue to be liable for any debts that she incurred, contracts that she signed, or wrongs that she committed before the marriage. Even though the husband and wife are now participating in a legal relationship, which is marriage, the husband does not bear any responsibility for the actions of the wife in any situation that may arise in the future. In the event that there is any uncertainty regarding the ownership of the property, the husband and wife have the option of submitting a summons application to the High Court or to a Session Court judge in the event that the value of the property falls within the jurisdiction of the latter, as stated in Section 11, subsection 1 of the Married Women Act. Last but not least, there is Section 15, which states that the rights and obligations of married women as outlined in the Married Women Act 1957 shall be the same as those of a feme sole. Muslim married women and their property rights and obligations are subject to Islamic law and the customs of Malaya, managing the relationships between husband and wife, inasmuch as these laws and customs rule the same way that we can apply. That is all from me. Thank you.
I am Aisha Imanina binti Azhar. My matric number is 288490.
Next, I will discuss about the effects of marriage on personal status and property of married women under Islamic Family Law Act 1984. There are 3 sections that are applicable under the effects of marriage on personal status and property of married women under the Islamic Family Law Act 1984. The first section that we will discuss is Section 127 that provides regarding ill treatment of wife. In Section 127, subsection 1, any man who ill treats his wife or cheats his wife of her property commits an offence and shall be punished with a fine not exceeding 1,000 ringgit or with imprisonment not exceeding 6 months or with both such fine and imprisonment. Meanwhile, in Section 127, subsection 2, the court may add additional order direct the man or woman who has been convicted under subsection 1 to compensate the wife or husband who has been cheated of her or his property, as the case may be. Next, in Section 128, it discusses about the failure to give proper justice to wife. It states that any person who fails to give proper justice to his wife, according to Hukum Syarak, can commit an offence and shall be punished with a fine not exceeding 1,000 ringgit or with imprisonment not exceeding 6 months or with both such fine and imprisonment. And lastly, in Section 129, it illustrates regarding disobedience of wife. It provides any woman who willfully disobey any order lawfully given by her husband according to Hukum Syarak commits an offence and shall be punished with a fine not exceeding 100 ringgit or in the case of a second or subsequent offence with a fine not exceeding 500 ringgit. To illustrate, by looking at Section 134A, subsection 2 of Islamic Family Law Act 1984 that states regarding Hukum Syarak, in the event of a lacuna or where any matter which is not expressly provided under the Islamic Family Law Act, the court shall apply Hukum Syarak. Hukum Syarak has been defined from Section 2 as the Mazhab Syafi'i or according one of the Mazhab Maliki, Hanafi or Hanbali. At the same time, Section 2 defines harta sepencarian as property jointly acquired by husband and wife during the subsistence of marriage in accordance with the conditions stipulated by Hukum Syarak.
I'm Tayalini Narayanasamy. Today I would like to explain cases on effect of marriage on status and property for Muslims. Under Section 4A, in case of Ahmad Azad bin Osman vs. Rozana binti Misbun, the respondent got Rm 10,000 from the appellant's husband after the appellant physically attacked the respondent's wife at home in front of their kids, maid and husband's personal chauffeur was the first battery. At the Permodalan National Berhad P&B registration desk, the appellant's husband also reprimanded and struck the respondent in the face and chest was the second battery. For this offence, the appellant was fined Rm 2,000. Additionally, the appellant assaulted the respondent once more in the parking lot was the third battery. The respondent's wife subsequently received compensation. 3 batteries were the basis for the respondent's case, which was brought in Session Court. The respondent sought special damages, general damages, aggravated damages and exemplary damages. The original case was upheld by the Session Court, which further mandated that the appellant pay Rm 30,000 in general damages, Rm 50,000 in aggravated damages and interest on the entire amount of damages. Under Section 9 Clause 2, in the case of Farida binti Datuk Talib vs. Muhammad Habibullah bin Mahmud, the plaintiff filed a lawsuit to stop her spouse, the defendant, from assaulting, harassing or molesting her and her family members. The defendant requested that the plaintiff's action be dismissed. The actions of violence and assault also qualified as hurt-causing crimes. The plaintiff cannot sue the defendant under Section 9 Clause 2 of the Marriage Women Ordinance 1957 because the claims of assault and abuse which constitute a tort are unrelated to the preservation of security of property. Since they both are Muslims, the claim is covered by Section 107 and 127 of the Islamic Family Law Act of 1984, and only Sharia courts, not the High Court, have jurisdiction. Under Section 9 Clause 4, in the case of Ray Kutuna Bibi, in this case, the defendant was accused of criminal breach of trust of her husband's property. The learned magistrate determined that the accusation was unfounded at the trial after the testimony of the witnesses, holding that a wife has joint possession of her husband's property and cannot be charged with disposing of her husband's property in any way. It was decided that because there is no equality of interest in Muslim law between husband and wife, a Muslim wife is free to take or criminally violate the trust with regard to husband's property. As a result, the Marriage Women Act 1957 was defeated by Islamic law. Thank you.
The position of husband and wives according to the Malaysian laws are separated and not seen as one legal entity. They both are entitled to their own rights for their own property and status. We unanimously agree, and we are of the opinion that the latest laws and principles in accordance with the effects of marriage towards status and property uphold the strong sense of justice, especially towards women. Women are naturally independent and deserving of their full rights and are liable towards obligations as a female without any prejudice either to married or unmarried women. This signifies the fact that Islam prohibits any form of substandard treatments towards wife. All of the provisions should be clearly and well interpreted by all in order for the society to be fully aware of the rights for Muslims for matters pertaining to marriage. It is so to ensure all parties get to enjoy all the lawfully entitled rights of their own. Thank you so much for your time and attention. We hope you are well informed and are enlightened about our topic today. Thank you.